Welcome to our podcast on tort law, a foundational topic for SQE candidates and first-year law students. This podcast contains the key elements of the Law of Tort. We start with a short presentation of the origins and development of tort law before discussing the basis of liability. We then explain in some detail the concepts of the duty of care, standard of care, causation, remoteness, and defenses. We pay specific attention to claims for battery, assault, false imprisonment, and intentional harm, before concluding with a discussion of the tort of defamation. This podcast was put together by Dr. Yanis Glinavos with the help of artificial intelligence tools. You can find other great podcasts on key law topics on Yanis's YouTube channel. Consider joining as a member for extra perks. Without further delay, we start with a short introduction of the origins and development of tort law, a key part of the common law system that shapes many legal principles and everyday interactions.
To understand tort law today, we need to look back at its historical roots. Tort law, as we know it, evolved from early medieval practices in England, where the primary goal was to maintain public order and peace. The royal courts began asserting jurisdiction over disputes involving trespasses. These were direct infringements upon a person's body or property. At its inception, tort law was closely intertwined with criminal law. Actions like battery, assault, and false imprisonment were not just private wrongs, but breaches of the king's peace. This dual nature shows how tort law originally aimed to address violent deeds directly affecting individuals or their property. By the 13th century, actions for trespass became more formalized, allowing plaintiffs to bring cases for direct injuries. However, the courts soon recognized a gap. Not all wrongs were direct. Thus, the action on the case emerged to cover indirect injuries. Unlike trespass, which required the defendant's action to be forceful or direct, the action on the case could address a wider range of wrongs, such as nuisance or defamation. This marked a significant development in tort law, broadening its scope to include more subtle forms of harm. In the early days, bringing a case to court required a specific writ, a formal written order from the court defining the nature of the claim. Writs played a crucial role in the development of tort law. They provided the structure for legal actions and ensured that each case fell within a recognized category. Over time, however, the strict formalism of writs became problematic. The rigidity of these forms made it difficult to address new or unique harms that didn't fit neatly into existing categories. By the 19th century, reforms such as the Common Law Procedure Act of 1852 and the Judicature Acts of the 1870s abolished the old forms of action, allowing for a more flexible and modern tort law system. Understanding the historical development of tort law is essential, especially for those preparing for the SQE or embarking on a legal career. The distinction between direct and indirect harms, the evolution of legal actions, and the abandonment of rigid forms all underpin modern tort doctrines. For instance, contemporary issues in tort, such as negligence and privacy, have their foundations in these historical distinctions. The history also reminds us that tort law is not static. It evolves to meet the changing needs of society, balancing the protection of individual rights with broader social interests. Tort law has come a long way from its medieval origins, where maintaining peace was the paramount concern. Today, it protects a wide range of interests, from personal safety to economic stability. For students and future practitioners, understanding its historical context provides a deeper appreciation of its principles and its role in shaping the legal landscape.
Stay tuned as we explore next bases of liability. Let us focus now on a crucial aspect of tort law, the interests it protects and the different bases of liability. This is an important area for both SQE candidates and first-year law students, because understanding what tort law aims to protect and how liability is determined forms the foundation for more advanced studies.
Let's start with what tort law actually protects. At its core, tort law is about safeguarding fundamental human interests against wrongful conduct. Think of it as a way for the law to step in when someone's rights are violated in a way that causes them harm or loss. But not all interests are protected equally. Some are considered more important than others, and this influences how the law responds. The highest priority is given to personal and proprietary interests. These include the protection of one's body from harm, freedom from physical restraint, and the protection of tangible property like land and goods. Torts like battery, assault, and trespass were originally developed to protect these very interests. Over time, tort law has expanded to offer even more robust protection for personal safety and property, including through the tort of negligence and others like nuisance and strict liability for inherently dangerous activities. Beyond personal and property interests, tort law also recognizes the importance of reputation. The tort of defamation, which includes libel and slander, is designed to protect individuals from false statements that could harm their standing in the community. However, the scope of protection has been somewhat limited in recent years, balancing the right to free speech with the need to protect reputation. We also have other interests that are safeguarded by tort law, though to a lesser extent. These include privacy, economic relations, and intellectual property. For example, while the law has been slower to fully develop protections for privacy, there are emerging areas where tort law is increasingly recognizing rights to personal information and seclusion. Likewise, while financial and business interests are protected through a variety of economic torts like fraud or interference with contractual relations, these protections are not as extensive as those for personal safety or property. Now, let's shift to the different bases of liability in tort law, which are the ways in which someone can be held legally responsible for harming another person. There are three main types: intentional conduct, negligence, and strict liability. First, intentional conduct. This is where the defendant deliberately engages in actions that infringe on another's protected interest. For example, in the case of battery or assault, it's not enough that harm occurs. There must be an intent to perform the harmful action. However, this doesn't always mean there's an intention to cause harm. For instance, if someone steps onto another's property thinking it's their own, they may still be liable for trespass even though they didn't intend any harm. Second, we have negligence. Negligence is all about failing to meet a standard of care that the law expects in certain situations. It doesn't require a deliberate act or an intention to cause harm. Instead, it covers situations where someone fails to act as a reasonable person would, and as a result, someone else suffers harm. This is a significant area in tort law because it covers so many everyday situations, from car accidents to medical malpractice. Finally, there's strict liability, which is the most straightforward, but also the most stringent basis for holding someone liable. Under strict liability, a defendant can be held responsible for certain harms even if they were not negligent or did not intend to cause harm. This typically applies in situations where the law wants to encourage extra caution, such as with dangerous animals or defective products. The idea is that those who engage in particularly hazardous activities should bear the cost of any resulting harm, regardless of their intent or care. Understanding these bases of liability helps us see how tort law balances different interests and concerns. Intentional torts focus on deliberate misconduct, negligence addresses carelessness, and strict liability imposes a duty to ensure safety in inherently dangerous situations. It's a complex interplay, but together, these concepts form the foundation of how tort law works to protect individual rights while promoting social responsibility. So why is this also important for law students and future practitioners? Because tort law isn't just about understanding who is right or wrong in a given case. It's about understanding the principles that govern our social interactions. By knowing what interests are protected and how liability is assigned, you're better equipped to analyze real-world legal problems, advise clients, and predict how courts might rule in specific situations.
I hope this helps clarify some of the foundational concepts in tort law. Next, we'll look deeper into the concept of the duty of care. We're now diving into one of the most fundamental concepts in negligence, the duty of care. This is a crucial topic for anyone studying law, especially SQE candidates and first-year law students, because the duty of care forms the foundation of most negligence claims. Understanding how this duty works is key to navigating the complexities of tort law.
So, what exactly is the duty of care? At its core, it's a legal obligation that requires individuals or entities to take reasonable care to avoid causing harm to others. For a negligence claim to succeed, it's not enough just to show that harm occurred. There must also be a duty of care owed by the defendant to the claimant. Without establishing this duty, the courts won't even consider whether a breach occurred or whether damages should be awarded. The idea of a duty of care didn't always exist in law as we know it today. Its roots go back to the late 18th and early 19th centuries, when courts began to recognize that certain relationships between people required a legal obligation to act carefully. The concept started to take shape in cases like Heaven v. Pender in 1883, which set the stage for the famous neighbor principle, articulated by Lord Atkin in Donahue v. Stevenson in 1932. According to this principle, you must take reasonable care to avoid acts or omissions that you can foresee would likely injure your neighbors, those who are closely and directly affected by your actions. But how do we determine when a duty of care exists in a new situation? That's where the Caparo test comes in. The Caparo Industries plc v. Dickman case in 1990 established a three-stage framework that courts use to decide whether a duty of care should be recognized. The first stage is foreseeability of harm. The question is whether a reasonable person in the defendant's position could foresee that their actions might cause harm to someone like the claimant. The second stage is proximity, which considers whether there is a close enough relationship between the parties. And the third stage asks whether it would be fair, just, and reasonable to impose a duty of care in the circumstances. This three-stage test provides a flexible but structured way for courts to decide whether a duty of care should exist in each case. Policy considerations also play a significant role in these decisions. Courts don't just think about the specific parties involved. They also consider the broader social impact of recognizing a duty of care. For example, they're generally more willing to impose duties in cases involving physical injury than those involving purely economic loss. Why? Because the law places a higher value on protecting personal safety than on safeguarding financial interests, which might be considered less tangible. Another approach to determining duty of care is the assumption of responsibility test. This test is mainly applied in cases involving economic loss or negligent misstatements. It was established in Hedley Byrne & Co. Limited v. Heller & Partners Limited in 1964, where the House of Lords recognized that a duty of care could arise when one party voluntarily assumes responsibility for another's welfare or financial interests, and that other party reasonably relies on this assumption. Finally, the scope of the duty of care is not limitless. Courts carefully define the scope to ensure that the duty is only applied where it is appropriate and justifiable. This means that not all harms or damages will be covered, and the duty might be limited to specific types of activities or relationships. For example, a doctor owes a duty of care to their patients regarding medical advice, but that duty does not extend to unrelated matters like giving investment tips. Understanding the duty of care is essential for anyone studying tort law, as it provides a framework for determining when one person should be legally responsible for preventing harm to another. It helps balance the interests of individual rights with broader social considerations, ensuring that the law evolves in a way that is fair and just.
I hope this overview of the duty of care has clarified its role in negligence cases and provided some insight into how courts decide when a duty exists. Next, we'll continue exploring negligence by looking at the standard of care and what it means to breach that standard. We are now moving to address an essential topic in negligence cases, the standard of care and what it means to breach that standard. This is a fundamental concept for anyone studying law because it helps determine whether a defendant should be held liable for harm caused by their actions or omissions.
Let's start by defining what we mean by the standard of care. In tort law, the standard of care refers to the level of caution and concern an ordinary, reasonable person would use in similar circumstances. It's a way of measuring whether the defendant's actions were appropriate given the situation. If a person's conduct falls below this standard and someone else is harmed as a result, they may be found to have breached their duty of care. But how do courts determine what this standard is? The standard of care is primarily objective, meaning it does not focus on what the defendant actually knew or intended, but rather on what a hypothetical reasonable person would have done in similar circumstances. This is important because it ensures consistency in the law. Everyone is held to the same standard, regardless of their individual skills or knowledge. One of the key cases illustrating this is Bolton v. Stone, 1951. In this case, a cricket ball hit a passerby outside a cricket ground, but it had only happened 6 times in 30 years. The court found that the cricket club had not breached its duty of care because a reasonable person wouldn't have taken extra precautions against such a rare event. This case shows that the standard of care depends on the likelihood of harm. Where the risk is minimal, the law does not expect excessive precautions. However, there are factors that can influence what is considered reasonable in any given situation. Courts take into account several factors, such as the likelihood and seriousness of harm, the cost and practicality of taking precautions, and the social utility of the defendant's conduct. For example, in Paris v. Stepney Borough Council, 1951, the court held that more precautions were required when an employee with only one eye was exposed to risks that could cause blindness in his remaining eye. Here, the severity of potential harm justified a higher standard of care. Another crucial aspect is how professional negligence is treated under the law. The standard of care for professionals, such as doctors or lawyers, is measured against what is expected from a reasonably competent member of that profession. In medical cases, the Bolam test from Bolam v. Freer Hospital Management Committee, 1957, is often applied. This test asks whether the professional's actions were in line with a responsible body of professional opinion. If so, they may not be found negligent, even if other experts would have acted differently. However, more recent developments have shown that the courts are willing to challenge professional opinion if it does not stand up to logical analysis. For instance, in Bolitho v. City and Hackney Health Authority, 1998, the court held that even a body of professional opinion must be reasonable and capable of withstanding logical scrutiny. This shift shows that while professional standards are important, they are not absolute. Courts will look critically at whether they are reasonable in context. Understanding these principles is crucial because they show how the law balances the need to protect individuals from harm with the recognition that some risk is inevitable in everyday life. The standard of care is not about guaranteeing absolute safety. Rather, it's about ensuring that people act reasonably to prevent foreseeable harm. Why is this important for law students and future practitioners? Knowing how the standard of care is determined and what constitutes a breach can help you assess whether a negligence claim is likely to succeed. It also underscores the importance of considering the context in which the harm occurred. Factors like the probability of harm, the potential severity, and the defendant's role all play a part in shaping legal outcomes.
I hope this has given you a clearer understanding of the standard of care and how it applies in negligence cases. Next, we'll explore causation and remoteness, 2 other key elements in tort law. Let's explore 2 critical elements in negligence cases, causation and remoteness of damage. Understanding these concepts is vital because even if a duty of care has been established and breached, a claimant must still prove that the defendant's actions caused their harm and that the harm was not too remote to be recoverable.
Let's start with causation, which is all about the link between the defendant's breach of duty and the damage suffered by the claimant. The basic test used by courts to establish this link is known as the but-for test. This asks whether the harm would have occurred but for the defendant's actions. If the answer is no, then causation is established, and the defendant can be held liable. However, if the harm would have happened anyway, even without the defendant's breach, then there is no causation. A classic case illustrating this is Barnett v. Chelsea and Kensington Hospital Management Committee, 1969. In this case, a man who had been poisoned with arsenic was sent home from the hospital without treatment, despite his symptoms. Sadly, he died, but the court found that even if the hospital had treated him, he would have died anyway because it was too late for an antidote. Therefore, the hospital's negligence did not cause his death, and the claim failed. But causation is not always straightforward. Sometimes the but-for test doesn't provide a clear answer, especially in cases involving multiple potential causes. This is where the courts have developed alternative approaches, such as the material contribution to risk principle. This principle was famously applied in Fairchild v. Glenhaven Funeral Services Ltd., 2003, where workers had been exposed to asbestos by multiple employers and developed mesothelioma. The courts allowed the claimants to succeed, even though it was impossible to prove which employer's breach had caused the disease. Instead, it was enough that each employer had materially increased the risk of harm. Now, let's talk about legal causation, which addresses whether the causal link between the breach and the damage is sufficient to hold the defendant legally responsible. One key concept here is the novus actus interveniens, or new intervening act, which can break the chain of causation. For instance, if an unforeseeable event occurs after the defendant's breach, causing further damage, the defendant may not be liable for that additional harm. The courts examine whether the intervening act was foreseeable and whether it was a natural response to the defendant's actions. Moving on to remoteness of damage, this concept limits the types of harm for which a defendant can be held liable. The leading case here is the Wagon Mound, number 1, 1961, where oil negligently discharged into a harbor caught fire and caused extensive damage. The court held that the defendants were not liable for the fire damage because it was not a foreseeable consequence of the oil spill. The kind of harm that materialized was too remote. A key rule in determining remoteness is that the harm must be of a kind or type that was reasonably foreseeable as a result of the defendant's negligence. This doesn't mean the exact sequence of events needs to be foreseeable, but the general nature of the damage must be. For example, in Hughes v. Lord Advocate, 1963, an explosion occurred after a boy knocked a paraffin lamp into a manhole. Even though the exact cause of the explosion wasn't predictable, the court held that the defendants were liable because it was foreseeable that leaving dangerous equipment unattended could lead to harm. Finally, there's the eggshell skull rule, which states that you must take your victim as you find them. This means that if a defendant's actions cause more severe harm to a claimant than would be expected due to a pre-existing condition, the defendant is still fully liable for all the harm caused. An illustrative case is Smith v. Leachbrain & Co. Ltd., 1962, where a man's minor burn led to cancer because of a pre-existing condition. The defendants were held liable for the full extent of the harm, despite the unexpected severity. Understanding causation and remoteness is crucial for law students because it shows how the law balances fairness with practical limitations on liability. It's not just about whether someone was careless. It's about whether their carelessness can fairly be said to have caused the harm, and whether that harm is something the law will recognize.
I hope this overview has clarified the principles of causation and remoteness in negligence law. Next, we'll explore defenses in tort law, which can limit or eliminate liability even when a claimant has established all the elements of negligence. Understanding these defenses is crucial because even when a claimant establishes all the elements of negligence, duty of care, breach, causation, and damage, a defendant can still avoid or reduce liability by successfully arguing a defense. We'll focus on two key defenses: contributory negligence and voluntary assumption of risk.
Let's start with contributory negligence, which is by far the most commonly used defense in negligence cases. Contributory negligence occurs when the claimant themselves fails to take reasonable care for their own safety, and this failure contributes to the harm they suffer. Essentially, it's about recognizing that more than one party may be at fault. Historically, any degree of contributory negligence would have completely barred the claimant from recovering damages. However, this harsh rule was replaced by the law reform, Contributory Negligence Act 1945. Under this act, if both the defendant and the claimant are at fault, the court will apportion the damages based on each party's share of responsibility. To determine contributory negligence, courts apply similar principles used to assess the defendant's breach of duty. The claimant's actions are measured against what a reasonable person would have done in their situation. Factors such as the likelihood and seriousness of harm, the cost of taking precautions, and the social utility of the claimant's actions are considered. For example, if a claimant was injured in a car accident and was not wearing a seatbelt, a court may find them partially at fault for their injuries, as in the case of Froome v. Butcher, 1976. Next, we have voluntary assumption of risk, also known by its Latin phrase, volenti non fit injuria, which means to one who consents, no harm is done. This defense applies when a claimant voluntarily accepts the risk of harm. If the defense is successful, the defendant is completely absolved of liability. However, this defense is not easy to establish. The defendant must prove that the claimant had full knowledge of the risk involved and voluntarily agreed to assume it. For instance, in Morris v. Murray, 1991, where a claimant willingly got into a plane with a pilot who had been drinking, the court found that the claimant had accepted the risk and the defense succeeded. It's important to note that the courts are generally reluctant to apply the voluntary assumption of risk defense, preferring to address issues of shared responsibility through contributory negligence. The reason is that contributory negligence allows for damages to be adjusted based on each party's level of fault, whereas voluntary assumption of risk completely bars recovery, which can be seen as overly harsh. To successfully argue voluntary assumption of risk, the defendant must show that the claimant was aware of the specific risk that led to the injury and consented to it freely. This is a high threshold. The court will scrutinize whether the claimant truly had a choice or if there were any factors, such as pressure or lack of information, that could invalidate the claim of voluntary acceptance. This is why in cases like Nettleship v. Weston, 1971, where a driving instructor was injured by a learner driver, the court did not find voluntary assumption of risk. The claimant had not freely accepted the risk, given the learner's lack of skill and the instructor's role in the situation. So why are these defenses important for law students and future practitioners? They illustrate how the law balances fairness and accountability. Defenses like contributory negligence allow the courts to recognize shared responsibility, while voluntary assumption of risk sets clear boundaries for when individuals can be said to accept certain dangers. Understanding these defenses helps you evaluate the strengths and weaknesses of a negligence case, providing a fuller picture of how liability is determined.
I hope this discussion on defenses has helped clarify their role in negligence law. We will now look at a series of violent actions and consider the liabilities they give rise to in the law of tort. We start with one of the fundamental torts, battery. Understanding battery is essential for any SQE candidate or first-year law student because it serves as a building block for many other legal principles related to personal harm and the protection of individual rights.
So, what exactly is battery in tort law? At its core, battery is an intentional tort that involves direct and intentional contact with another person without their consent. It's important to note that this contact doesn't have to be harmful or violent. It just needs to be unwanted and unpermitted. For example, if someone deliberately pushes another person without any lawful reason, that action could be considered battery, regardless of whether it caused physical injury. Now, let's break down the elements of battery to better understand how it works. The first key element is a positive act by the defendant. This means that the defendant must have performed some voluntary action that led to the contact. It's not enough for the contact to be accidental or purely reflexive. There has to be an intentional, voluntary act. The second element is unpermitted contact. This is where the core of battery lies. The contact must occur without the claimant's consent. This doesn't just mean physical harm. Even the slightest touch, if unwanted, can amount to a battery. However, in daily life, we accept a lot of contact, like brushing against someone in a crowded place or tapping someone on the shoulder to get their attention. For battery to be actionable, the contact has to go beyond what society considers normal and acceptable. The next critical element is directness. The act must have a direct causal link to the contact with the claimant. For example, if someone throws a rock and it hits another person, that's a direct act. However, if they place a rock on a path and someone trips over it hours later, that may not meet the standard of directness required for battery. The principle of directness ensures that the law focuses on actions that are immediate and clear in their causation of harm. Battery also involves the element of intention. But here's where it gets interesting. The intention required for battery is not an intention to cause harm or injury, but merely the intention to perform the act itself. So even if someone didn't intend to cause any injury but deliberately made contact, that can still be a battery. An important case that illustrates this is Latang v. Cooper, where it was determined that battery requires a positive act, not merely negligence. Let's talk about the defenses available against a claim of battery. One of the main defenses is consent. If the person being touched has agreed to the contact, then no battery has occurred. Consent can be explicit, like agreeing to participate in a contact sport, or implied, like navigating through a crowded area. Another defense is self-defense, where a person can argue that they used reasonable force to protect themselves from immediate harm. This defense is strictly scrutinized to ensure that the force used was necessary and proportionate to the threat faced. There's also the issue of hostility in the context of battery. The law recognizes that not every unpermitted touch is hostile or intended to harm. For example, a friendly slap on the back might technically be an unpermitted touch, but without hostility, it's unlikely to be treated as battery. Hostility in this context refers to actions that are unwarranted, malicious, or done with an intention that goes beyond what society would generally accept as reasonable or acceptable conduct. Another intriguing aspect of battery is the concept of transferred intent. This occurs when a person intends to make contact with one individual but unintentionally makes contact with another. In such cases, the law treats the unintended contact as if it were intended, allowing for a battery claim by the person who was actually touched. This concept is particularly useful in situations where someone's reckless actions cause harm beyond their original intention. Understanding battery and its elements is essential for law students because it illustrates how the law protects personal autonomy and dignity. It underscores the principle that any interference with a person's body must be justified, whether by consent, necessity, or another valid reason. As you delve deeper into tort law, you'll see how battery intersects with other torts, like assault and false imprisonment, building a complex web of legal rules designed to balance individual rights and societal norms.
I hope this overview helps clarify the key elements and defenses of battery and tort law. Next, we'll explore another related tort, assault. Stay tuned as we continue to break down these fundamental legal concepts. Turning to another key tort, assault. While many people think of assault as involving physical violence, in the realm of tort law, it has a different and more specific meaning. Understanding assault is vital for SQE candidates and first-year law students because it sets the stage for grasping how the law protects personal security and mental peace.
So, what is assault in tort law? Unlike battery, which involves actual physical contact, assault is about the apprehension of imminent contact. In simpler terms, assault occurs when one person creates in another person a reasonable fear or expectation of imminent harmful or offensive contact. The classic example is raising a fist to someone's face as if to punch them, even if no punch is actually thrown. The key idea is that the claimant reasonably believes that they are about to be hit. Let's break down the elements of assault to understand how it works. The first element is an intentional act by the defendant. Just like with battery, the defendant's action must be deliberate. However, with assault, the focus is on the defendant's behavior, creating a perception of an immediate threat. This could be a raised fist, a sudden movement, or even threatening words. But remember, mere words alone aren't always enough unless they are accompanied by some act or context that makes the threat feel real and imminent. The next element is the reasonable apprehension of immediate harmful or offensive contact. This means that the claimant must actually fear that contact is about to occur, and this fear must be reasonable. If a person is overly paranoid or hypersensitive, their reaction alone isn't enough to prove assault. The test here is objective. Would a reasonable person in the same situation have felt threatened by the defendant's actions? Another crucial aspect of assault is the immediacy of the threat. The perceived threat of contact must be imminent. A future threat, like someone saying, "I'll punch you tomorrow," does not qualify as assault under tort law. There has to be an immediate threat that puts the claimant in a state of fear or apprehension right then and there. Intent is also a key factor in assault. The defendant must have intended to cause the claimant to apprehend imminent harmful or offensive contact. This doesn't necessarily mean the defendant wanted to cause actual harm. They only need to have intended to create the perception or fear of imminent harm. For example, if someone jokingly raises a fist, but does it in such a way that the other person reasonably believes they're about to be hit, that could still constitute assault, even if the defendant meant no harm. Let's talk about some defenses against a claim of assault. One of the main defenses is consent. If the claimant consented to the action, either explicitly or implicitly, then the claim of assault cannot stand. For instance, in sports or playful interactions, participants often consent to a certain level of contact or perceived threats as part of the game. Another important defense is self-defense. If the defendant can show they were acting to protect themselves from an immediate threat and that their response was proportionate to that threat, this can serve as a valid defense. Additionally, words can negate an assault. If the defendant's words clarify that no assault is intended, then the action may not amount to an assault. For instance, if someone raises a hand as if to strike but immediately says, "I'm not actually going to hit you," this may negate the assault by making clear there is no imminent threat. Now, let's address why understanding assault is important for law students and future practitioners. Assault is not just a minor tort. It plays a significant role in maintaining social order and protecting personal autonomy. It shows how the law values not only our physical safety, but also our mental peace and security. Knowing the nuances of assault, such as what constitutes reasonable apprehension or what defenses are available, equips you to analyze a wide range of legal scenarios and advise clients effectively. As we can see, assault in tort law is less about physical violence and more about protecting individuals from the fear or anticipation of harm. It emphasizes the importance of consent, intent, and the immediacy of threats in evaluating whether an assault has occurred.
I hope this breakdown of assault helps clarify its elements and defenses. Next, we'll explore another essential tort, false imprisonment, which is all about the unlawful restriction of someone's freedom. Now, we're diving into another fundamental tort, false imprisonment. This tort may sound dramatic, but it's actually about something very relatable: the right to move freely without being unlawfully restrained. For SQE candidates and first-year law students, understanding false imprisonment is crucial because it covers important aspects of personal liberty and the legal limits on restraining someone's freedom.
So, what is false imprisonment in tort law? False imprisonment occurs when one person unlawfully restricts another person's freedom of movement. This doesn't necessarily mean locking someone in a room or tying them up. It can be as simple as preventing someone from leaving a particular place. The key is that the restriction must be total and without lawful justification. Even a short period of confinement or a small space can count, provided the individual is completely restricted from moving freely in any direction. Let's break down the elements of false imprisonment to understand how it operates. The first element is the defendant's intention. False imprisonment requires an intentional act by the defendant that causes the confinement. This means that the defendant must have meant to confine the claimant, even if they did not intend any harm. For example, if a security guard mistakenly locks a store at closing time with a customer still inside, it could be false imprisonment if the guard intentionally locked the door, even without intending to confine anyone. The second element is the total restraint of the claimant's freedom of movement. To prove false imprisonment, there must be no reasonable means of escape. It's not enough that the claimant feels confined or perceives a barrier. There has to be an actual and total restriction on their ability to move in any direction. If a person can leave through a safe and reasonable exit, then there is no false imprisonment. However, if the only way out would expose them to significant danger or harm, the law may consider it a total restraint. Another important aspect is that the claimant does not need to be aware of their confinement at the time it happens. This is an interesting point because in many torts, the claimant must be conscious of the wrongdoing. In false imprisonment, however, a person can still claim even if they weren't immediately aware they were being confined. For example, if a patient is sedated in a hospital and the staff deliberately prevent them from leaving without medical justification, this could still amount to false imprisonment, even if the patient was unaware at the time. Now, let's talk about defenses against a claim of false imprisonment. One of the main defenses is lawful authority. This defense applies when the defendant has a legal right to confine someone. For instance, police officers acting under a lawful arrest warrant are not committing false imprisonment, provided they comply with legal procedures. Another defense is consent. If the claimant voluntarily agreed to the confinement, then there is no false imprisonment. This might apply in situations like voluntary confinement for medical treatment or security checks at an airport. Necessity can also serve as a defense. If the defendant can show that restraining someone was necessary to prevent harm to themselves, the claimant, or others, the action might not be considered false imprisonment. For example, if a bouncer at a club detains a person who is posing an immediate threat to others, this might be justified under the doctrine of necessity. An interesting aspect of false imprisonment is the calculation of damages. Unlike other torts, damages in false imprisonment are not always based on physical harm or financial loss. They often focus on compensating for the loss of liberty and any distress caused by the confinement. The duration of confinement, the conditions under which it occurred, and the claimant's awareness of it all factor into the damages awarded. In some cases, even a very brief but complete restriction of movement can lead to significant compensation. So, why is understanding false imprisonment important for future lawyers and legal practitioners? False imprisonment isn't just about dramatic cases of kidnapping or unlawful detention. It's about understanding the boundaries of personal freedom in everyday contexts. Knowing what constitutes lawful versus unlawful confinement can help you navigate a wide range of legal scenarios, from advising clients to representing them in court. False imprisonment shows us that the law places a high value on individual liberty and freedom of movement. It underscores the idea that no one should be deprived of their freedom without just cause or due process. As you continue to study tort law, keep in mind that these principles are not just theoretical. They have real-life applications that affect people's everyday lives.
I hope this discussion on false imprisonment has helped clarify its elements and defenses. Next, we'll explore intentional infliction of harm, a tort that focuses on the deliberate creation of distress or suffering. Here, we're exploring a less common but very important tort. This tort is crucial for understanding how the law protects individuals from deliberate emotional and psychological harm.
The intentional infliction of harm, sometimes called the tort of intentional infliction of emotional distress, involves situations where someone deliberately causes severe mental or emotional suffering to another person. This isn't just about hurting someone's feelings or causing minor distress. The conduct must be extreme and outrageous, going beyond the bounds of acceptable behavior in a civilized society. It's a tort designed to protect against conduct that society deems intolerable and wants to discourage. Let's dive into the elements of this tort to understand it better. The first element is the defendant's intentional or reckless conduct. To be liable, the defendant must have acted either with the intent to cause emotional distress or with reckless disregard for the effect their actions would have. Intentional conduct means the defendant deliberately aimed to cause harm. Reckless conduct means the defendant knew or should have known that their actions would likely result in severe emotional distress, but they went ahead anyway. The second element is the requirement that the conduct be extreme and outrageous. This is a high bar to meet. The conduct must be so severe that it would shock the conscience of a reasonable person. It's not enough for the behavior to be rude or offensive. It must be genuinely outrageous and intolerable. For example, persistently harassing someone with threats of violence or engaging in prolonged verbal abuse that causes psychological trauma could meet this standard. The next element is causation, which means that the defendant's conduct must have directly caused the emotional distress. This is an important factor because it links the defendant's actions to the harm suffered by the claimant. The claimant needs to show that it was the defendant's extreme and outrageous conduct that led to their severe emotional distress, rather than some other unrelated factor. The final element is that the claimant must have suffered severe emotional distress as a result of the defendant's conduct. The distress must be more than temporary annoyance or minor upset. It must be serious and long-lasting, often requiring medical attention or therapy. The courts will consider the intensity and duration of the distress, and sometimes they might require evidence like medical records or testimony from mental health professionals to prove the severity of the harm. Now let's discuss some defenses against a claim of intentional infliction of harm. One of the main defenses is consent. If the claimant consented to the conduct, the defendant might not be held liable. However, this defense is not easy to establish because the conduct must be truly outrageous, and it's unlikely that a claimant would consent to such behavior. Another defense is the exercise of a legal right. For instance, a person may be lawfully entitled to perform an action that unintentionally causes distress to another. This is often seen in scenarios involving legal processes, like evictions or debt collections. As long as the defendant is acting within their legal rights and without malice, this can be a strong defense against claims of intentional infliction of harm. A unique aspect of this tort is its role in situations where other legal remedies might not be available. For example, in cases where there is no physical injury or direct financial loss, this tort provides a way to seek justice for psychological harm. It underscores the idea that the law recognizes emotional well-being as an interest worthy of protection, even in the absence of more tangible harms. Why is understanding the intentional infliction of harm important for law students and future practitioners? This tort represents an evolution in the law to address the complexities of modern society, where emotional and psychological harms are increasingly recognized as significant. It highlights the law's role in balancing freedom of expression and action with the need to protect individuals from severe emotional and psychological harm. As you study tort law, remember that these principles are not just abstract ideas. They have real-world consequences. Cases involving intentional infliction of harm often deal with highly sensitive situations, and understanding the nuances of this tort will prepare you to navigate complex legal and ethical issues.
I hope this overview has clarified the key elements and defenses of the intentional infliction of harm. Next, we deep dive into the tort of defamation. Stay tuned, and as always, thanks for listening and keep learning. We now dive into the key elements and defenses of the tort of defamation, a complex area of law that protects an individual's reputation from unjust harm.
Defamation involves a statement that harms someone's reputation, and it comes in two forms: libel and slander. Libel covers defamatory statements in a permanent form, like written words or images, while slander pertains to temporary, spoken words or gestures. The distinction between libel and slander is important because, traditionally, libel is actionable without proof of damage, whereas slander often requires evidence of actual damage unless it falls into specific exceptions. The recent development of defamation law has been shaped by the balance between protecting reputation and respecting freedom of expression. The introduction of the Defamation Act 2013 in England brought significant changes, particularly around the concept of serious harm. Now, for a statement to be considered defamatory, it must cause or be likely to cause serious harm to the claimant's reputation. For businesses, this harm must result in serious financial loss. To understand what counts as defamation, we must consider the tests courts use to determine whether a statement is defamatory. One test is whether the statement exposes the claimant to ridicule, hatred, or contempt. Another, the lowering of reputation test, asks if the statement would lower the claimant in the estimation of right-thinking members of society. A third test, known as the shun and avoid test, considers whether the statement would cause others to avoid or shun the claimant. Each of these tests reflects different ways that defamation can harm reputation, from direct insults to statements that indirectly damage one's social standing. Once it's established that a statement could be defamatory, the next question is whether it refers to the claimant. A defamatory statement must be about the claimant specifically, not just a general comment that doesn't clearly identify them. If a statement is made about a group, individual members can only claim defamation if the group is small enough that a reasonable person would assume the statement applies to each member. Interestingly, not everyone can sue for defamation. Natural persons and companies can, but charities and public authorities, for example, generally cannot. This limitation reflects a balance between protecting reputations and preserving free expression, especially concerning criticism of governmental bodies. Publication is another crucial element in a defamation claim. For a statement to be defamatory, it must be published to a third party, meaning someone other than the claimant and the defendant. This is a broad requirement and includes not just traditional forms of publication, like newspapers, but also newer forms, like online content. The single publication rule under the Defamation Act 2013 provides that a claimant cannot bring multiple claims for defamation for the same statement, even if it's published on multiple occasions. This rule helps limit endless litigation over repeated statements. Defamation law also addresses the roles of intermediaries, such as internet service providers, who may be involved in the dissemination of defamatory material. Generally, intermediaries are not liable unless they are actively involved in publishing the statement. Defenses are a critical aspect of defamation law, providing a way for defendants to avoid or reduce liability even if the core elements of defamation are proven. One key defense is the defense of truth, which applies if the defendant can prove that the statement in question is substantially true. If a statement is true, it cannot be defamatory, regardless of its impact on the claimant's reputation. The defendant has the burden of proof in these cases, meaning they must provide evidence that justifies the truth of their statement. Another defense is innocent dissemination, which protects parties like booksellers and internet service providers who distribute defamatory content without knowing it was defamatory. This defense reflects a practical understanding of the complexities involved in controlling every piece of content that passes through one's hands. Other defenses include absolute and qualified privilege. Absolute privilege applies in very specific situations, such as statements made in Parliament or during judicial proceedings, where free expression is considered so important that it overrides any reputational harm. Qualified privilege, on the other hand, applies in situations where there is a moral, legal, or social duty to communicate the information, provided that it is done without malice. An example of qualified privilege is a reference given by an employer about a former employee. As long as the employer is acting in good faith, they are protected from a defamation claim. Public interest is another important defense, especially in matters that concern the public. The Defamation Act 2013 introduced a statutory defense for publications made on matters of public interest, which requires the defendant to show that the statement was on a subject of public interest and that they reasonably believed that publishing it was in the public interest. The courts will consider whether the publisher has acted responsibly in gathering, verifying, and reporting the information. Related to this is the defense of honest opinion, which protects expressions of opinion rather than statements of fact. For this defense to apply, the opinion must be based on true facts or privileged material, and it must be an honestly held opinion. This defense is crucial in protecting freedom of speech, particularly in the context of reviews, commentary, and criticism. Understanding these elements and defenses is essential for anyone studying law because they illustrate the delicate balance between protecting reputations and upholding free expression. Defamation law constantly evolves to reflect societal changes, technological developments, and shifting attitudes toward privacy and public discourse. For law students and future practitioners, mastering this area of law involves not just learning the rules, but also appreciating the values and principles that underlie them. This concludes our discussion of the tort of defamation. We've covered the essential elements of a defamation claim, including defamatory meaning, reference to the claimant, and publication, as well as the various defenses available to those accused of defamation. Each of these areas highlights the complex interplay between protecting reputation and allowing free speech, a balance that remains central to the law's development.
This concludes our discussion of the tort of defamation and our podcast on the Law of Tort. Thank you for listening and see you next time. Click the video on your screen for another core key lecture by Dr. Yanis.